Ladies and gentlemen, good morning, good afternoon, or good evening. Wherever you are in the world, we appreciate you being with us right now. This is Lovey Life, a Dome podcast. Dome is a digital and bilingual media company specialized in law at the supranational level. So, for all news, comments, analysis related to law in Africa and in the rest of the world, go to our website, dome-online.com, and follow us on our social media platforms, the links of which are listed below. This, however, is neither a technical nor a political podcast. To be honest, sometimes it's barely a legal one. The only prerequisite needed is to have an open mind and 30 minutes or so to spare. We sometimes will have guests from everywhere around the world, and we will always be keen to hear your thoughts. We have a fantastic episode for you today, so please stay with us and weigh in while we argue the case, Lovey Life. Well, people, Roe v. Wade fell. It not only fell, but it fell without ceremony. It was reversed on a Friday afternoon, the last day of the June session of a very conservative United States Supreme Court, after putting up a fight for nearly half a century. To be absolutely clear, and I feel I have to say this at the beginning of each episode, this podcast is not going to argue either for or against that decision. If you have listened to our previous episode, and we would be really grateful if you did, you know that for the purpose of this series, we are only dealing with the substantive issues of a case insofar as it highlights its reception in society. For legal and technical breakdowns of the law and summary of the cases, please go to our website, keeping in mind that we focus on international law. So, if you are interested in knowing what's going on in the International Criminal Court, or the African Court of Human and People's Rights, or other supranational tribunals, Dome is the place for you to go. But, for Lovey Life, what matters to us is the legal outcome of a case in the court of law and its aftermath in the court of public opinion. So, this is a disclaimer. Both pro-life and pro-choice are welcome in this space and can have their own views and see things from their prisms, as long as they are respectful of others. When we decided to do an episode around the theme of changes in the law, we looked, well, not we, I looked for another case study. I genuinely did not want to have people lashing out because they were triggered. But, truth to be told, I don't think there will be many cases that are better suited for the concept of the program than this one, because it perfectly embodies the interaction, or sometimes lack thereof, between law and life. So, here goes nothing. Roe v. Wade it is. This has been one of the most famous, talked about, and impactful cases of the US court system for almost 50 years. I'm not even hyping it up. Whether one was for or against it, it was a seminal case. I'm sure the facts are known to most, but for those who are unfamiliar with them, here is a brief summary. In 1969, Ms. Norma McCorvey, a woman in her 20s, living in difficult and impoverished circumstances in Texas, sought to terminate an unwanted pregnancy after having given birth previously to 2 children placed for adoption. At that time, abortion was legal in the state of Texas, but only for the purpose of saving a woman's life. Ms. McCorvey tried unsuccessfully to have the procedure done in the back alley, quote-unquote, as it were referred to at the time, meaning, of course, illegally, before being introduced to 2 Texan attorneys who wanted to have a go at the anti-abortion laws which were affecting, at the time, countless women across the country. In the legal documents, Ms. McCorvey was referred to as Jane Roe. The legal plan of attack was to sue Henry Wade, then District Attorney of Dallas County, on behalf not only of their client, but also on behalf of, and this is a direct quote, other women who were or might become pregnant and want to consider all options. End of the quote. After a lengthy process, the case found itself before the United States Supreme Court, and on January 22, 1973, in a 7-2 decision, the highest court of the land ruled that the Texas law banning abortion was illegal because, essentially, according to Justice Harry Blackmun, writing for the majority, a woman's right to an abortion was implicit to the right of privacy protected by the 14th Amendment of the U.S. Constitution. What that meant was that abortion was therefore legalized effectively nationwide. The court operated a distinction between the different trimesters during pregnancy. The choice to end a pregnancy during the first trimester was that of the pregnant woman alone. In the second trimester, the government could regulate but not ban it, and in the third, the state could prohibit abortion to protect a fetus that could survive on its own outside the womb, except when a woman's health was in danger. This has remained the law in the United States for 49 years and 6 months, until the case Dobbs versus Jackson Women's Health Organization that was delivered on June 24, 2022. The legal question of the case centered around the Mississippi's Gestational Age Act, which essentially banned most abortion after 15 weeks of pregnancy, which went against the solution adopted in Roe v. Wade. The case was taken by the Supreme Court, and, in a 6-3 decision, the majority ruled that the Constitution does not confer a right to abortion, that Roe v. Wade, as well as Casey, another case that was taken by the Supreme Court in 1992, are overruled, and the authority to regulate abortion is returned to the people and their elective representatives. To say that this decision divided the public at large is an understatement. A flurry of articles appeared on the front page of every newspaper, both in America and worldwide. Everyone in the States felt either vindicated or betrayed. Everyone outside the States had something to say about what it meant to the country, because the situation seemed to be that the more conservative states enacted or would enact almost immediately laws that would either ban or significantly restrict abortion, while more liberal ones would continue to provide access to the procedure. In the following days, the story of a 10-year-old kid that was pregnant as a result of a rape and had to cross state lines from Ohio to Indianapolis to have this pregnancy terminated became for some the symbol of the drama that was in store as a direct result of the end of Roe v. Wade, while others said that this case was instrumentalized and that the facts surrounding this case were distorted. I think we can all agree that regardless of one's belief system, the specific case of this child was truly heartbreaking. The important point for us is that Roe v. Wade itself was already a change in the law, as most states penalized abortion during the 19th and a good part of the 20th century. In that regard, much like Dobbs is viewed today, the construction of the 14th Amendment by the Supreme Court in 1973 was deemed either a major milestone or a terrible mistake, depending on one's sensibility. We are using this case study to illustrate many points. The first and most obvious one is that law is a dynamic discipline. I know it may not look like it because we are living in what is certainly the most fast-paced era, while on the other hand, there are some very old law and statutes that are still enforced today. Yet and still, it evolves depending on the social context of the jurisdiction in which it is applied, mainly through case law, as exemplified by the interpretation of the 14th Amendment of the United States Constitution. Another point illustrated by our case study is that law does not exist in a vacuum. It is extremely sensitive to the jurisdiction to which it is applied. But the question of knowing if the changes in the law are driven by society, or if society reacts and adapts to the law that are voted, is the legal equivalent of asking which came first, the chicken or the egg. The point is moot. In the case study we have taken as an example, law worked as a pendulum, swinging back and forth between two opposing positions. But that's not it. Law can be either reactive or preemptive. Let's give an example of both. As an example of a reactive legislation, think for a moment of all the national legislations, international treaties, guidelines, white papers, pledges that have been enacted in the last 3 decades about the environment. The pattern is fairly clear. The preservation of the environment became a trending topic in the 90s because the scientific community rang the alarm about the trend of global warming and its impact on our way of life. Over time, it became a real concern and found itself on the political agendas around the world, sometimes making and/or breaking campaigns. This is very straightforward, as you can see. As an example of a preemptive legislation, well, you only have to think of the criminal code, where we don't wait around for a situation to repeat itself enough times before deciding that certain behaviors are simply never okay. At the international level, think of the treaties regarding the non-proliferation of nuclear weapons. It appeared very clearly at the end of World War II and during the Cold War to everyone involved that nuclear weapons needed to be regulated one way or the other. By the way, if you wish to have a look at these treaties, they are all available in the multilateral treaty section on our international and comparative page on DOM's website, the link of which is in the description. A third point, one that is uncomfortable to face but needs to be addressed. Law can be flawed. And here, to be clear, I'm not basing this argument on Roe v. Wade. I'm talking in general terms, and I'm going to take different examples. So, flaws in the law can happen for at least 2 reasons. A practical one and an intrinsic one. Let's tackle the practical first. Well, during the drafting of a legislative proposal, there are many competing factors that come into play. One of the simplest examples could be taxation. Try as you may, you cannot move a single comma in a taxation code anywhere around the world without lobbyists of every possible interest group being on the offensive. As a result, if, and it is a big if any change manages to be enacted into law, it is more often than not a compromise that will confuse more than clarify or advance anything. I remember studying international tax law and thinking, it is lucky that the bilateral treaties to avoid double taxation follow the same template, because it would be a complete mess otherwise. A second and more important reason why law can be flawed is that it is not only written by, but as importantly, enforced by people. And we are flawed creatures. It would be unrealistic to think that the legislations enacted will hit the mark perfectly every time. And dare I say, there have been some colossal F-ups over time and space. And when I say F, F-U-C-K, let's never forget that for a very long time, slavery was legal. It was institutionalized from Gorée, Senegal, to every major port in Europe and to America, and in the islands across the world. When something this massive happens on that scale, changes in the law are only the very first step of atonement. This aspect of the law actually explains why groups within a society or society as a whole may rebel. Because clearly, law at that point does not represent justice. The three branches of government, executive, legislative, and judicial, are then presented with a choice: either changes in the law or complete chaos. So, if we summarize the various points we have made so far, we have said that law is dynamic, sensitive to the context in which it is applied, and can be flawed, with society playing the role of a gatekeeper when needs be. Fairly straightforward, I'm sure you would agree. The last point I'm going to make is, I believe, the more interesting one. So please, bear with me. I think the argument can be made that in today's climate, law is and will likely remain at odds with society, regardless of any change actually voted into law. I believe this has to do with the social fabric of the time and the characteristic of the rule of law. What do I mean by that? Well, tell me if you agree, but more and more, people lean into their uniqueness. It is now more than ever the basis of one's identity. Whereas previously, the attachment to the group was prevalent. Think that most of the time the first information that you would volunteer was either citizenship or ethnicity, things that would attach you to a group. Well, people are more and more centered around their personal experience. Whether we hate, like, or love that trend is entirely up to each of us, but we must recognize it. Things do not cease to exist because they are being ignored. So mostly, this is where we are in society, I think. Perhaps I'm wrong, so let me know what you think. The thing is, law does not and cannot work like that. The first characteristic of the rule of law is that it is general in its application, the Latin locution being iur erga omnes est. What does that mean? Simply that every person, legal or natural, that falls within the scope of the law, as usually defined at the outset of the relevant piece of legislation, must comply with that text, irrespective of their feeling on the subject. Furthermore, if it is a well-written law, the exceptions specifically provided for are limited. But you have to realize that a piece of legislation will never be unanimous, because it cannot be tailored to everyone's specific needs and desires. As we have stated earlier in the program, there are competing interests for everything. To come back to Roe v. Wade, there will never be unanimity around such a hot issue, especially because behind this, we are talking about triggering notions like one's belief system and the sanctity of life for both the unborn child and the pregnant woman. Things are bound to get messy. Still, law cannot care about anyone's particular feelings. That is not its function. It is supposed to help regulate conduct in society as best possible. Personal inclinations be damned. The second characteristic of law is that it is abstract. It can never target one person, legal or natural. It is either for everyone or a specific group of persons chosen on the basis of objective criteria. It must be impersonal, which is one of the reasons why Lady Justice is always depicted blind. In theory, she is not concerned about anything other than the legal qualification of a set of facts and the potential ramification in terms of sanctions that this set of facts can carry. That's it. The third characteristic of law is that it is mandatory. No one can pick and choose what rules they want to follow. This also means, and it goes without saying, that there must be some consequences to the choice made by someone to ignore the law, whether you have to pay a fine or have to spend some time in prison. Without that threat, there is absolutely no chance that this could work. Now, to be clear, though I have said that law is mandatory, not all laws are created equal in terms of strength of the obligation imposed on people. Obviously, rules that deal with public interest or state security are more binding than the rules that govern private contracts, where, usually, what applies is freedom of the parties. Look at international law, where the subject of the law are mostly states and international organizations. Even states, which are sovereign, by the way, cannot do whatever they want all the time. Yes, they get to choose which international instrument they sign, ratify, or adhere to, and they get to conduct their own affairs in their country. But there are rules that they must comply with, regardless of sovereignty. Those are customary international law, natural law, jus cogens, etc., etc. So, to summarize, the rule of law is general, abstract, mandatory, and binding. It has always been and is likely to always remain so. However, as I said, we are living in a society where the notion of self and individuality become increasingly important. In theory, there's nothing wrong with that, of course. Problem may arise, however, if and when the manifestation of this individuality can no longer peacefully be part of the social fabric and starts to either exist in the fringes of law, picking and choosing what rules to follow, or, which is more dangerous, do everything possible to change or even abolish the notion of the rule of law. For all the reasons we have exposed, we need to realize that changes in the law are inevitable. It is a never-ending process, and very few pieces of legislation will be unanimously acclaimed. But, and this point needs to be made, there is a difference between reactive and reactionary. Law is sensitive to the context in which it is applied. We have already said that multiple times. But we cannot and we should not change law every time one's feelings are hurt, because that would create a legal uncertainty that would be unsustainable for everyone. Thank you so much for being with us today. I want to hear what you have to say. Do you have any comments, questions? Does it make sense? Does it not? Leave a comment below. The transcript of the program will be available on DOME's website in both French and English. If you have enjoyed this episode, please consider sharing, liking it, and subscribing to the show. We will be back with our next episode next week. In the meantime, please stay safe and take care of yourself.